limited, so I'm happy to focus my attention on whatever areas the court finds most interesting. But let me start off talking about the admission of the
appeal
404B evidence.
Of my Valentine
Mr. Cox was charged with possessing 2 guns during the course of 2 separate transactions involving the transfer of guns.
Alan Dubois
That occurred on May 14th and June 27th,
oral
2012. The government, however, devoted about half of its trial presentation presenting evidence about a 3rd transaction that occurred on May 21st, where there was no allegation that, or no evidence at all, that Mr. Cox possessed a gun at any point.
No evidence at all. Listen.
Transaction. Now, the government purported to introduce this evidence pursuant to Rule 404B, but this evidence served no proper 404B purpose, and perhaps implicitly recognized.
Why is this 404B?
It's Judge Wilkerson, United States Judge Wilkerson, Allison Wilkerson.
Sort of sandwich equidistant.
Not Allison. Judge Wilkerson.
The May 12th sale was May 21st sale was sandwiched equidistant almost between the first charged sale and the last charged sale. So it could be almost be seen as part of a continuous story. It's because normally when you are dealing with 404B evidence, you have the 404B
Judge
evidence
explaining how to use 404B evidence.
Criminal conduct, or it's took place years before. Temporally, it's distant, more distant.
Now listen what the lawyers say why it was considered 404.
Right in the swim of facts.
Well, Your Honor, a few answers to that. First off, the government presented it.
The government.
That's how they presented it to the court. That's the grounds on which the court introduced it or admitted it, and that's the grounds that the jury was instructed on how to
and the jury.
The government.
We don't need to. I mean, we're not bound by that.
Well, I certainly think you should be, Your Honor, because
You're not
if the jury is
bound.
told that evidence is they're to consider evidence for a certain purpose, yet the government says now for the first time on appeal, this is the first time
on
that they've raised
appeal.
this issue. Normally, those types of evidence, those types of arguments are not considered for the first time on appeal.
But can't we affirm, if we agree with the outcome, aren't we free to
Judge
affirm
Duncan.
on any basis that appears in the record?
I don't think so, Your Honor, because
Affirm on
of the
any
fact
basis.
that
Wow.
these were not 2 equal bases for admission. 404B evidence serves one purpose. This sort of intrinsic evidence serves another purpose. But I would say, even taken on its own terms,
So they did more than was necessary by, going through all the 404B hoops.
No. They did much less than is necessary, because 404B they're told this serves this purpose, and you are to consider for this ground. If they're not to consider for that ground, they shouldn't have been instructed that way.
You need to give a limiting instruction for intrinsic evidence.
Well, exactly. They did give I think it's sort of a misnomer to call it a limiting instruction. It's certainly a cautionary instruction, but it tells the jury how they are to consider this evidence. If they weren't supposed to consider this evidence for this purpose, they shouldn't have been told that.
The
But
jury.
let me say this, even taken on its own terms, this was not intrinsic to the offense. The government in its brief says
Well, let's assume that was what I was going to ask. I mean, let's assume that it isn't intrinsic. Let's assume that it is appropriately 404B. Why is it objectionable then? Wasn't the question of whether or not Cox knowingly possessed firearms a disputed issue?
It was the only disputed issue, Your Honor.
Right.
And this evidence
to his knowledge. I'm sorry.
No, I was going to say exactly the same thing.
Well,
I mean, because, and if I could speak to you for a second, I agree with you. It's not intrinsic evidence. I don't think it is of the crimes charged, but it goes directly to his knowledge. His defense was he was just a matchmaker. He was putting this, couple people together, and this evidence shows that he was into the gun trade. He was negotiating the price of a gun. He was talking to people about guns. He knew this shows guilty knowledge, it seems to me, and his intent pretty much as clearly as any 404 type evidence would.
Well, two answers, Your Honor. First, intent is not an element of 922G. Knowledge is, but...
Well, knowledge and intent to the extent that he knew knew what was going on. It's
Right.
not specific intent, but intent, general intent is always something that has to be established. There was an accident or mistake
that's
or,
correct, Karen.
or something
but,
like that.
But I think the argument that the government makes and you're adverting to conflates two different types of knowledge. There was no dispute in the record that Mr. Cox knew that these gun transactions were being brokered and that they were occurring. The only thing, I think this evidence might have been admissible had Mr. Cox, the only issue was the knowingness of his possession. During a transaction in which there was no allegation of possession, I simply don't think it logically follows that can shed any light on whether or not on some other occasion involving some other guns, Mr. Cox might have knowingly possessed them. The evidence, Mr. Cox's defense was not that, oh, I had this gun, but I didn't know it was there, or I had this gun, but I thought it was a toy. The only knowledge that this May 21st transaction goes to is his knowledge of whether these gun transactions were going on. And that might be very relevant if he had been charged with illicit transfer of a weapon.
I'm sorry, go ahead, please.
How would the government, in your view, be able to show constructive possession?
There was no aspect of constructive possession on the
Judge Duncan.
first transaction.
Fourth Circuit Court of Appeals,
Judge
Duncan.
But doesn't it shows knowledge, and doesn't it go to show knowledge, as Judge Keenan pointed out, and absence of mistake?
He's not arguing that there was a mistake, and it doesn't show the knowledge of knowing possession.
Theories
it has absolutely nothing to do with possession.
But it doesn't have to be crafted to his argument. That's not what 404B requires.
But it does have to be crafted to the government's burden of proof and the elements.
That he actually constructively possessed guns.
That's correct. And I think if you look at this record, there is nothing about the May 21st transaction that sheds any light onto the knowingness, constructive or otherwise, of his possession.
Doesn't his defense make it relevant?
Judge Keenan, this is the one that wrote the opinion.
A lot stronger if he hadn't used this matchmaker defense. But essentially, he's saying, I'm an innocent broker.
There she is, blaming the lawyers.
A in touch with B. And it seems to me that puts this in play.
Well, Your Honor, again, not to belabor the point, but I simply don't see that.
We don't see it, Judge Keenan.
I would definitely agree with you, Your Honor. If this was a case involving a charge of illegal transfer of a weapon, this would clearly be relevant. But this was not a case of illegal transfer.
Y'all got to go back to the indictment.
And all this May 21st evidence shows is, as Your Honor points out, that there was a brokerage aspect. Now, of course, Mr. Cox doesn't contest that, but putting that aside, focusing on the government's burden of proof
on the government
and the elements of the offense, there's nothing about that particular knowledge that this May 21st
or any other charge
sheds any light on whatsoever. It simply is put out there to show that he is the type of person, the type of bad person who would engage in these types of illicit transactions. And I think I would, also point out the fact that this really was the tail that wagged the dog.
The tail that wagged the dog. The government
spent almost half of his trial presentation on this one transaction, again, to emphasize the point where there was no allegation that Mr. Cox ever saw that gun, was ever touched that gun, was ever in the same room as that gun. Yet they went through this entire interminable discussion and description of how this came. He was going to the Walmart, then he's not going to the Walmart. None of which involved Mr. Cox. And at one point, the district court even says, we are getting way far afield here.
Louise Wood Flanagan, Eastern District of North Carolina.
Given the convoluted manner in which you tried to present it and the way in which the witness was speaking. So I think the danger or the prejudice suffered by Mr. Cox in this case is exactly, I think, the danger that I'm worried that this, that I'm not dispelling, which is the jury is focused on the wrong thing. They're focused on, the government makes this appear as if this is a case about illegal gun transfer, illegal gun transaction.
And I was not indicted for that. Judge Wilkerson.
The trial court calls on these evidentiary
he
matters
lost in the sauce, like Joe Biden.
In this case,
you put 3 Joe Bidens up there. Expect I'm gonna get a fair trial. You put 3 Joe Bidens up there to review my case. Come on, man. This is 2025. Hey, Trump, listen, man. Let's open these cases back up, man. 3-panel judges just like Joe Biden. They can't see the law. Let's go back to the original Constitution and what the law was designed to do. Go pull up Lionel Cox versus United States oral argument attached. The judges don't know, so how can a layman jury that never went to law school know? Explain that to me. 7 years spent behind politics. Obama administration, yes. Politics.